Okay, are we ready? Can people hear in the back? Good, we've tried to turn the mic up a little bit. Okay, we have a fair bit to cover, miles to go before you sleep. So here we go. Look in your statutory book at page 65, if you would. You will remember the hour ended, and we were looking at history, for lack of a better word, the legislative history of Rule 410. And here is the current version of 410 restyled. Structure is familiar to you, prohibited use, exceptions. The prohibited uses say in a civil or criminal case, evidence of the following is not admissible against the defendant who made the plea or participated in plea discussions. And we say a guilty plea later withdrawn, a nolo plea, statements made in Rule 11, statements made during discussion with an attorney for the prosecuting authority if the discussions didn't result in a guilty plea. And then the exceptions here are quite limited. So with that as background, let's look at some problems, just a few, and make sure we understand the rule. So we start on page 106 with number 1. D pleads guilty to embezzling $100,000 from the bank where he worked as a teller. The bank subsequently sues him civilly and seeks to offer his guilty plea against him. D objects, citing Rule 410. What ruling? Okay, so we have a guilty plea followed by a civil case. The plaintiff in the civil case would like to use which I guess is a bank here, would like to use the guilty plea against our teller. Does Rule 410 permit that? The biggest problem is always the first question. Yeah, go ahead.
I think it does.
Because?
Because this seems to forbid against using guilty pleas against someone like when it's withdrawn.
Period. Okay. So if you look at that rule, it says a guilty plea later withdrawn. This guilty plea wasn't withdrawn. And those of you who are civil procedure experts, which I know is most of you, will recall that this is what collateral estoppel is all about. Right? The burden of proof in the civil case is lower. He's had a chance to adjudicate it. He's pled guilty. You can use this against him in the civil case, and you will not have a trial on liability. Okay? The next question is, would your answer be different if the defendant had pleaded nolo contendere, no contest? And the answer is?
Yes.
Because?
Because number 2 says nolo contendere.
Period. Right? And that's the difference. A nolo plea cannot be used collaterally. Right? That's its principal difference from a guilty plea. Otherwise, it's the same. You can be sentenced on a nolo plea just like a guilty plea. You can actually use a nolo plea to impeach someone, but it cannot be used civilly to get collateral estoppel effect, and hence that rule is written, a guilty plea later withdrawn, but it just says a nolo plea. Okay, so that is number 1. Let's go on and do number 2. D pleads guilty, and in his plea allocution admits under oath that he knowingly smuggled cocaine into the country in his luggage. With the permission of the court, he later withdraws his guilty plea and proceeds to trial. At trial, D testifies that he had no knowledge that the substance in his bag was cocaine. The government seeks to impeach D with his statement in his plea allocution. What result? Go ahead. Can they? Totally. And you can't use it substantively, and you can't use it to impeach. Right? And if you were writing a brief on this, you might say the following. 1, the language of the rule says these are exceptions, and one of them is not impeachment. 2, as you might recall from last time when we looked at the legislative history, there was a point in this history where impeachment use was an exception. Right? It no longer is, which suggests that the legislative history supports the language, that Congress did not intend to allow impeachment use. It thought about it, and then thought again, and there is no impeachment exception. Okay? So that's our answer to number 2. Now, you could use it in a perjury prosecution. If you decide you're going to prosecute him for perjury because he's lied, either in his first pleading or a trial or whenever. That is a permissible use. Doesn't happen very often, but what's important for our purposes is you cannot use it to impeach. And let's see where that gets us. Number 3. Ready? We're uncharacteristically going to do these problems in order. Number 3. D was arrested on heroin distribution charges by DEA agent A, who gave him Miranda warnings. D then informed A that he had cooperated with the government in the past and be willing to do so in the future. In the course of this conversation, D made incriminating statements relating to the crime for which he had been arrested. Later that day, D met in a pre-arraignment conference with the Assistant United States Attorney B and had a similar conversation. And let's just stop there, right? And the question is, can either of those statements, the statement that he made to the DEA agent or the statement he made prior to arraignment to the Assistant United States Attorney, can either of those be used against him under Rule 410? You got another one? Go ahead. You just put that microphone on.
The statement made with the agent, with the DEA agent, can be used against him because the DEA agent had no power to make a plea bargain.
Just right. And if you look at the language of the rule, A4, it is not made during plea discussions with an attorney for the prosecuting authority. And how about the statement to the Assistant United States Attorney?
I'm less sure, but I would say that it's also it can also be used against him depending on what was the context of the discussion, because we don't know if it was a plea.
That's exactly right. Now we have a prosecuting authority, but this may not be plea discussions. This may just be questioning by the Assistant United States Attorney. So you need 2 things. You need it to be plea discussions, and presumably it needs to be, or by the rule, it needs to be with an attorney for the government. If you look in your materials, there is a case called Ratchlin, and go to page 89 in your blue supplement. And if you go down about to the 3rd full paragraph, it says, page 89, blue supplement, it says, we carved out an exception to this rule, however, where the law enforcement official is acting with the express authority from a government attorney. Now, a couple of things. I don't think courts carve out exceptions to statutes. Right? I think it's a bit like saying, another expression I'm not fond of is, the spirit of this law compels us to do the following. I'm sort of old-fashioned. I don't think laws have spirits. And either the law says it or it doesn't, and I don't think courts are in the business of carving out exceptions, except maybe if compelled on some constitutional ground. But having said that, there is something about the fact that if the attorney says to the defendant, look, these are plea discussions, I'm the attorney for the government, I'm authorizing you, the agent, to be my proxy, right? For my purposes, that agent is the attorney for the government, right? He has been authorized. So I don't think you need to carve out an exception. It just seems to me in that situation, given the express authorization, he is, in effect, the attorney for the government. But the important thing here is, and your advisory committee note is helpful on this, This rule does not exclude statements you make in police custody, for example. Right? They are not statements to a government agent during plea discussions. They may be inadmissible under Miranda. There may be some other exclusionary rule in criminal procedure, but Rule 410 only excludes statements to a government attorney, right? Perhaps also his express agent during plea discussions. Okay, let's see where that takes us to. And I think the answer is, let's see, number 6, right? Number 6 says the following. D was indicted for Medicare fraud, a felony offense carrying the potential of 10 years in jail. During plea discussions, the prosecutor offered D a misdemeanor plea with a promise of no jail. D rejected the offer and opted for trial. At trial, his counsel seeks to introduce proof of the misdemeanor offer and D's rejection of it to show D's consciousness of innocence. The government objects under Rule 10. What result? So now my argument as defense counsel is, look, this was such a generous offer. My client is charged with a felony. He faces substantial jail. He got this offer of a misdemeanor with no jail. He turned it down. I want to prove that he got the offer. I want to prove he turned it down, because only an innocent man would do that, and the jury should know what happened here because it goes to his state of mind, namely that he's innocent. Okay, 410.
It should cover.
Because
It's not against the defendant.
it's not being used against the defendant. So at least 410 won't keep it out. If you were the prosecutor, is there another argument you might make to keep it out? Yep.
The probative value is substantially outweighed by the prejudice.
Yeah, or by the confusion, right? Or however you might put it. I mean, I think this probably stays out under 403, right? And you should say to yourself, okay, 410, we only know 2 other rules, right? So 403 is the likely place to go. And the reason I say it's a 403 issue is you're going to wind up, if this comes in, with the prosecution perhaps proving why it made the offer, right? Maybe for all we know, they were trying to protect the witness who they were concerned about. There may have been a lot of other things going on. They may have decided, look, this offer, we're going to offer a misdemeanor, he's a legislator, and the misdemeanor will cost them his job, and that's sufficient sanction. And you're going to wind up having a trial that includes among its components why this offer was made, why it was turned down, and that really can lead you far afield, right? And that, it may well be, I think most judges, many judges, would keep it out. Although I should tell you there's a case called Biaggi where a judge let something like this in because he read 410 and said 410 says against the defendant. This is not against the defendant. This is being offered by the defendant for the defendant. Now, it's a nice problem in the following sense. If we want to talk about statutory construction, which is not a bad thing to be sensitive to. And one of the things that I hope comes out of this course is a sensitivity to the language of statutes. Right? I remember I said the first night, Felix Frankfurter's admonition to young lawyers, read the statute, read the statute, read the statute, the 3 most important lessons. And it is terribly important as a lawyer, whether you're practicing tax or litigating, that you read the statute. So look with me at page 100. And just look at the evolution of this. Okay, so our original version, 1969, said, in a civil or criminal proceeding involving the person who made the offer, right? If that were the language, 410 would keep this out, right? Because this involves the person who made the offer. Now go down to, look at the next one, the 71. It just says it's not admissible in any civil or criminal proceeding. Presumably, this is a civil or criminal proceeding. you couldn't use it. Now go down to the next one. In any civil or criminal proceeding against the person who made the plea or offer, right? And this seems to me to be language that is ambiguous, and to use Justice Souter's word, artless. And what's the ambiguity in this language? Why, if this were the language, would you have trouble deciding problem number 6? Anyone? In any civil or criminal proceeding against the person who made the plea or offer. Yep. That microphone on?
The lack of punctuation makes it unclear whether the proceeding or the usage is against the defendant.
That's right. In other words, this is a criminal proceeding against the defendant, right? But it's not. But if the question is it admissible against the defendant? It's not being offered against the defendant. It's being offered in his favor. So against the person who made the plea or offer is not put in a very good place, right? And so go over to the next page. And look down the bottom, right? And we've done a better job here. No, maybe not. Let's take a look at the current version. So go to your statutory book. Better. Look at the page 65 in your statute. In a civil or criminal case, evidence of the following is not admissible against the defendant who made the plea or participated in the plea discussion. We've removed the ambiguity by replacing the against, or better still, replacing the in a civil or criminal proceeding. We move that to the front, right? So this language, as I say in the 71 version, is ambiguous because of where the against phrase is placed. Now, my guess is in the drafting process, nobody thought about it, right? Which is one of the things that makes drafting so hard. But over time, people thought about it so that when we got to the current version, we removed the ambiguity. Okay, let's see what's next. Okay, that gets us to Mezzanato, another Supreme Court case. And Mezzanato is in your book at, let's see if we can find it, at 91. It is a Justice Thomas opinion, and it's 1995. And in order to understand Mezzanato, you need a little bit of background, and so here we go. Look with me at page, let's see if we can find this, look at page 102. And this is for a client of mine. And this is what are sometimes called proffer agreements, interview agreements, or most famously, Queen for the Day agreements. And to understand the last phrase, you need to know a little television history. And that is, before your time, I think, the first reality television show was a show called Queen for the Day. And it followed, the script was as follows. It was the person at the center of this was always a housewife. And always an unhappy housewife. And she was brought on the show, and all of her best friends, typically high school friends, dispersed across the country, were brought back to tell her what a great person she was. And at the end of the show, she got a refrigerator. And she was Queen for the Day. And so these agreements, somehow along the line, I think first here in New York, got named Queen for the Day agreements. And I had a proffer recently in Texas, and the assistant said to me, "Do you want to sign a Queen for the Day agreement?" And I said, "Do you know where that term came from?" And he said no, and I said, well, let me tell you some television history, and repeated the same story. And these agreements work the following. Let's say I represent a client, and this happens lots of times, and the government wants to talk to that person. And we're not talking plea discussions. They are involved in an investigation. And I decide that there's no reason for me to resist that request. I could force the government to go get immunity order from the Department of Justice. I could say, we're not talking to you. But many times I'll say to a client, look, if you're telling me the truth, you don't have any exposure. I'd rather not say to the government, we don't want to talk to you. I'd rather not say get an immunity order, because I think it would suggest you've done something wrong. It might put a target on your back where there shouldn't be one. And so they're offering you a Queen for the Day agreement, and we should take it. Now, we're not talking plea discussions. And a Queen for the Day agreement in that context is limited protection for your client. It means that the words your client says in that meeting cannot be used directly against them if for some reason a case were made against them. Right? They can be used to impeach your client if your client were to get on the witness stand and say something different than what they said at the meeting. And they can be used for leads. And what I always say to my clients is what that means is if you say you murdered somebody, right, that can't be used against you. Unless you get on a witness stand someday and say, I didn't murder somebody, and then they can say, didn't you tell us that you did? But it can be used for leads. So if you say, I murdered somebody and I buried their body at the foot of the Brooklyn Bridge, they can dig it up and your fingerprints are on it. They can bring a charge against you because it can be used for leads. True immunity, you can't use it in any way. So this is sort of a limited form of immunity, and I'll frequently say to my clients, some protection is better than none. Let's take a Queen for the Day agreement. Okay? Now, on occasion, I've had clients. Recently, I represented a president of a university, right? And I said to them, look, the protection here is sort of limited, right? They can use it for leads. They can use it for impeachment. I don't want people to say you needed an immunity order if it ever were to leak out. And I'd like to walk in and say, you know, I'm here with President so-and-so, and we don't want a Queen for the Day agreement. Right? We don't need it. We don't want it. We're happy to talk to you. But that's just a decision about, you know, your client's reputation, the way you present yourself. But these Queen for a Day agreements are given out like candy to people who are called in to be interviewed. Okay? So far, no evidentiary issue. Now, what about when it changes? So your client has now been indicted, and the government calls and says, is your client interested in cooperating? And you say he might be, and they say, well, we'd like to talk to him. Okay? And we'd like to talk to him as part of plea discussions as to whether we should give him a more lenient plea because he's a cooperator and will testify against people down the line. Okay? Now think about that Queen for the Day agreement again. Same language. Can't be used in case in chief. Can be used for impeachment, right? And can be used for leads. Right? In comes your client, and he says, I sold cocaine with John Smith. And the plea discussions break down. For whatever reason, either the government doesn't believe him or doesn't want to use him, and now your client's gone to trial. Can the agent get on the stand and testify to what he said? No. You've got a Queen for the Day agreement that says can't be used in case in chief. If your client gets on the witness stand and says, I never had anything to do with cocaine, can they use it against him? Can they impeach him with what he said in plea discussions? And here's where the evidentiary issue arises. If there were no Queen for the Day agreement, the answer would be, this is a statement made during plea discussions with the prosecuting attorney, and we've already satisfied ourselves that you can't use it to impeach. Right? So this Queen for the Day agreement, which when your client is coming in just during the course of investigation, gives protection. When your client is engaged in plea discussions, it takes away protections. It is not very queenly. Because what it says is it can be used for impeachment purposes. And the rule and the legislative history of 410 say it can't be used for impeachment purposes. So that is the framework for Mezzanotto, because basically what we're saying is the parties have entered into an agreement that says, right, Rule 410 will not apply. It will not apply, and we have crafted our own agreement that will apply, and a term of that agreement is it can be used for impeachment. Okay? Hence the question in Mezzanotto, can you contract around the federal rules of evidence? Or at least can you contract around Rule 410? And I think I said the first night of class, for those of you who are baseball fans, right, we have an infield fly rule. I used to know it, understand it. I've forgotten it. But I think it's runners on second base, and any pop fly, you're automatically out, something like that. Managers come out, they say to each other, I've never understood the infield fly rule. Let's have a written agreement that it doesn't apply in this game. Right? And you would say, I'm sorry, this is baseball. Right? The infield fly rule is part of baseball. You can't come out and say, tonight, 2 strikes and you're out. Right? Because we want to move it a little more quickly. It may rain 2 strikes and you're out. You can't contract around the rules of baseball. The question is, can you contract around the rules of evidence? Can you simply say, 410 doesn't apply, here's our substitute? And Justice Thomas says, with that long-winded backdrop, any Justice Thomas fans? Enemies? Got it? Who's got an answer here? Mezzanotto comes out how? Go ahead.
Thomas says you can opt out.
Okay. Next question. And Thomas says, look, you can. And in a certain sense, we do it every day because think about the hearsay rules. Typically, if you don't object to hearsay, it's going to come in. And even that in itself is a way of contracting around the rules. Rarely will the judge say, I'm sorry, that's hearsay, it's inadmissible. Typically, the judge will wait for an objection. If he doesn't get one, if she doesn't get one, the evidence comes in. And that is a way, in sort of an implied fashion, that lawyers, parties are contracting around the rules of evidence. Can you contract around everything in a criminal case or civil case? Can you contract around all these rules? Can you contract around procedures, or is there any limitation on this?
I believe Justice Thomas finds that absent Congress saying you cannot opt out or supplying conditions of the opt-out, then there is I guess you assume you can opt out.
Okay, any limitations on it? Yep.
It must be entered into voluntarily and knowingly.
Totally. Anything else that might limit it? Yep.
You can't undermine confidence in.
So if I said we agree it's a criminal case, let's just try it to a preponderance. Could you do that? Probably not, right? Does Thomas give an example of what might undermine confidence? Yep. Yep, a trial by 12 orangutans, he says, would undermine confidence in the criminal justice process. And I've always thought, if that is your example, it suggests you can contract around most things, right? If the question we ask ourselves is, let me see, is this like trying by 12 orangutans? We're going to allow people to contract around most rules of evidence. Now, I can tell you, polygraphs are inadmissible, right? We'll get there when we talk about expert testimony. There are cases where the parties agree that a polygraph should come in. Most judges will not allow that to happen. So there are some limitations. Most judges will simply say, I think the polygraph results are too confusing for the jury. For the jury to decide these issues. The jury is the fact finder, not the polygraphist. Is that how one says it? Polygamist? Whatever the right word is. So that probably you can't contract around. But the answer is, unlike baseball, Mezzanotto says you're going to be able to contract around most of these rules of evidence. And as I say, it happens every day when people simply don't object to hearsay rules. Now, what about a plea agreement that says the following? If you come in and talk to us, not only can we use it to impeach you, but we can use it in case in chief. You come in at your peril. And so it's different than Mezzanotto. I have a much broader contract. Mezzanotto, the agreement was 410 applies, except we can use it to impeach you. This is basically, if you come in during plea discussions, you talk at your peril. 410 gives you no protection. Can you do that? Can you contract so that it is it permits case in chief use? And look, if you will, at page 104. So here is a letter, and I did an appeal in this case, and I found this in the file. In this case, the limitations are as follows. Any statements made by your client are on the record. That is, the statements he makes can and will be used against him, except as limited below. And what I commend you to do at some point is read what's below. I can't find any exception below. So as far as I can tell, this is an agreement that says anything you say can be used against you. The rest of it, as I say, there's a lot there, but it doesn't seem to me to accept anything. So this really is a full use clean for the day agreement, totally overriding Rule 410. Is that permissible? Yep, microphone on.
So that seems to be Justice Ginsburg's concurrence, which I think is necessary to the majority, so it sort of pokes a hole in the holding here.
You're right, which is, let's see the math. We've got 9, right?
Right.
And 2 dissent, Souter and Stevens. If we take away the 3, that leaves 6 in the 7 in the majority, 7 to 2, right? And if we take away the Ginsburg, O'Connor, Breyer, that doesn't leave us a majority.
Right.
Right? Do Ginsburg, Breyer, and O'Connor say it can't be used in case in chief?
They don't. They just sort of take the time out to make clear that they're not reaching that question.
Totally. Okay. So now you are sitting in the circuit, and this case comes up that they have said they're not reaching, and it is case in chief use. It is the Northern District of New York plea agreement, and you are the circuit judge, and the question is, can you override 410 to that effect? And your answer?
I would probably heed the concurrence here that's saying that it might undermine the plea bargaining process if we allow that.
And the counter argument?
Maybe Justice Thomas's point that these allowing override of 410 might tend towards truth.
Yeah. Or it's not 12 guerrillas, right? So if you read that majority to say, look, there's a strong presumption that you can contract, unless it's 12 guerrillas, case in chief use, look, it's certainly more favorable to the government, but it may not be 12 guerrillas. And this case arose shortly after this in the D.C. Circuit. They were sensitive to the concurrence, and they said the majority language, even the 4-person language here is so strong, and your point is good to say it's not a majority, it's really a plurality when you take away the 3, is so strong that the presumption is you can contract. And so the D.C. Circuit and now Second Circuit has followed, saying case in chief use is permissible. Okay? So that presumption of being able to waive these federal rules of evidence is indeed a strong one. And that, there are a lot of LLM students in the class, and my sense is you've reached the point in the semester already where you say, I can't believe these rules, right? I mean, who has rules of evidence in any event? And then to be told on top of them, I mean, if I were to say to you, if there's a rule in your country, can the parties say, tonight we're not going to follow it? You would say, I'm sorry, we don't have that many rules, and we follow them, right? Our answer is, we have a lot of rules, as you've come to learn, and if the parties choose to contract around them, Mezzanano says, by and large, they can. Okay? Okay, let's see where that brings us. Okay, 407, moving on or backwards. And I'm not going to spend a lot of time on 407, and I'm mostly going to lecture. But here we go. Page 55 in your text. When measures are taken that would have made an earlier injury or harm less likely to occur, evidence of the subsequent measure is not admissible to prove negligence, culpable conduct, a defect in a product or design, a need for a warning or instruction, but are exceptions, are permissible purposes, but the court may admit this evidence for another purpose, such as impeachment or, if disputed, proving ownership, control, or the feasibility of precautionary measures. And the question is sort of what's going on here. And the answer is there seem to be two things that underscore this rule on subsequent remedial measures. And the first you can see in the venerable Supreme Court decision on page 108 of your text of Columbia versus Hawthorne, where if you go to page 109, you'll see the notion that says, from Justice Bramwell, second to last, penultimate paragraph, people do not furnish evidence against themselves simply by adopting a new plan. I think that a proposition to the contrary would be barbarous. It would be, as I often have occasion to tell juries, to hold that because the world gets wiser as it gets older, therefore it was foolish before. And this really sounds in 403. What it is to say, when juries learn that you've made a remedial repair, there is a likelihood that it will think, well, if you did it now, you could have done it before, right? And those of you who are psychology students may well be familiar with the notion of hindsight bias, the notion that says when you look back and you see things in the past and think they're much more likely than they actually were. It is the wisdom of hindsight, right? And so part of what's going on in this rule is to say we're not going to let the juries learn about these subsequent remedial measures because they're going to think that if they did it then, they could have done it then. Probably the more powerful consideration, the advisory committee note calls it the more impressive ground, is that we want to encourage repairs. And the concern is that if I know that if I make a repair, it can be used against me in court, I will be less likely to make the repair. Right? And we'll come back and talk about it, but that for your advisory committee was the more impressive ground. The case in your material is Flaminio, which is at 110. It is a Judge Posner opinion. Judge Posner, as you probably know, having resigned in the last few weeks, but sat with great distinction on the Seventh Circuit for many years. This is Justice Posner interpreting the Rule 407 prior to a 1997 amendment. And so look with me down the bottom of 110. And the rule then said, when, after an event, measures are taken which are taken previously would have made the event less likely to occur, evidence of subsequent measures is not admissible to prove negligence or culpable conduct in connection with the event. The rule does not require, etc. And the issue in Flaminio was, well, how does this rule apply in a strict liability case? So let's say there is an injury, an accident, a power saw goes bad. In this case, it is a motorcycle accident. The company makes a change in the product after the accident. Here, if I can remember what happened, the redesign changes there's a trade-off between weave and wobble, and I think they reduce the wobble, but they may increase the weave with their new design. But clearly they've made a new design. And the plaintiff sues in negligence and strict liability, which you remember well from your tort class. And the question is, can subsequent remedial repair evidence be admissible? And many courts read this rule and said it's not admissible to prove negligence or culpable conduct, but strict liability is not negligence or culpable conduct. By definition, it's not culpable conduct. It is strict liability. And therefore, it can be admitted not on the negligence claim, but on the strict liability claim. Right? And Posner, who unlike Easterbrook, is not a textualist, not a literalist. Posner's statutory interpretation is very much, what are the consequences of my decision? Right? It is the sort of law and economics in Posner transmogrified or carried over into a theory of statutory interpretation. And so here is Posner, the bottom of 112 in the left-hand column. We are not impressed, says Posner, second sentence of that last fragmented paragraph on 112. We're not persuaded by the purely semantic argument to the contrary that since culpable Congress is not an issue in such a case, the defendant is liable even if he is not blameworthy, and the rule is inapplicable by its own terms, right? And I've always loved that sentence because what Posner calls the purely semantic argument is what Scalia would call the language of the statute, right? And for Scalia, if the language is clear, you don't go any further. For Posner, he's not going to be deterred by the purely semantic argument. He wants to know what are the consequences of ruling one way or the other. And he goes through the economic analysis as he sees it, but he also says something that I think is quite wise, which is think about what would have happened here if the decision were it's admissible in a negligence case, but it's not admissible in a strict liability case. We're going to follow the language of the statute. And I take it the answer is, if you tried this case, evidence of subsequent remedial repairs would come in. You would tell the jury you can only consider it on the strict liability claim. You can't consider it on the negligence claim. And the jury would say, that is an instruction I cannot possibly follow. Right? I mean, you just can't compartmentalize your mind that way. So the result would be, you might say to yourself, okay, let's just sever them. We'll have one trial on negligence and one trial on strict liability. To which the answer is, we don't have the resources to try any cases. We should not be trying every case twice. Right? And that's what it would mean. You try one, you try the strict liability, you'd admit it. You try the negligence separately, you wouldn't admit it. That is madness, or at least a recipe for madness. So there's a strong argument here to say it should be admitted on strict liability just so you can have a rational trial system. Right? Posner thinks it also should be admitted because it encourages remedial repairs. That is the most impressive ground, says the advisory committee. That is the law and economic ground, says Posner. I'm never quite sure I believe it. I mean, I think about people sitting out front of their house and somebody slips on the sidewalk on a snowy day, and you look out the window and you say to yourself, you know, maybe I should shovel the sidewalk. To which your son, friend, spouse says, you better not, you know, that might be able to be used against you in court. And you say, boy, that's right, let's just let people slip all day. Right? I mean, I'm not sure that this rule really does encourage people to make remedial repairs one way or the other. And one of the things that interests me is, look in your book at page 117. Start at 116. Maine used to have a rule that says, top of 116, evidence of subsequent measures is admissible. Turn over to 117. At some point, Maine changed it and said is not admissible. But if you go down the bottom of 117, the great state of Rhode Island, as far as I can tell, is the only state in the country that says when after an event measures are taken which have taken previously would have made the event less likely to occur, evidence of subsequent measures is admissible. And I've always wondered whether because of this one has less subsequent repairs in Rhode Island. Right? Now, even if you tried to answer the question, I'm not sure you could. If you have a manufacturer in Rhode Island, right, you could wind up with diversity jurisdiction. You'd be in federal court where the rule is different. If you manufacture in Rhode Island but it's sold over in Massachusetts, you could wind up in Massachusetts where the rule is different. So I'm not sure that the answer here is, you know, it's going to affect people's behavior in Rhode Island, that their rule is different, because their product could wind up anywhere and their case could wind up in federal court. But it might be worth calling somebody in Rhode Island who had a company and said, are you aware of this rule, and does it affect your behavior in any way? One of the wonderful things about evidence scholarship is that we refuse to do any empirical research. Right? Try getting an article published in the Columbia Law Review that says the following: evidence of subsequent remedial repairs in Rhode Island. Right? That is not getting accepted in the Columbia Law Review. If it said, and Wittgenstein, there's a chance it might get accepted in the Columbia Law Review.